which we hope to take in the order listed. After the first case, we're going to take a break, and we invite all of you to join us for coffee in the Commons, which is through the doors to your right. I trust everyone has had the workings of the clock explained to them, particularly for the appellant. When the yellow light comes on, that means you're into your rebuttal time. When the red light comes on, that means you're out of time, including your rebuttal time. Okay, the first case is Sunbelt Healthcare versus Galva. We've allotted 15 minutes to decide.
Good morning, Your Honors. May it please the Court. My name is John Crotty, and I represent the appellant, Sunbelt Healthcare and Adventist Health System. I would ask the Court to allow me to reserve 3 minutes for rebuttal. Your Honors, the appellant has appealed an order of the Judge of Compensation Claims dated February 28, 2008, which awards the appellee a one-time change of doctor pursuant to Florida Statute Section 440.13, subsection 2F. And we've raised 4 issues on the appeal. First, that the Judge of Compensation Claims incorrectly refused to admit into evidence Exhibit 6, which was a document showing that the appellee, through her attorney, had previously selected a one-time change in orthopedic doctors. Second, the appellant asserts that the Judge of Compensation Claims erred in concluding the appellee was entitled to a second change of doctors when the appellant stopped providing medical benefits through a managed care arrangement. And the third and fourth issues concerned issues of waiver and estoppel.
Didn't issue 3 more or less say, no matter what, on your issue 1 at least, it doesn't matter, because had I admitted it, I still would have said there was no waiver there, and the claimant was still entitled to do it.
Well, Your Honor, I believe the Judge of Compensation Claims, in addressing the waiver issue, held that as a matter of law, the employer carrier could not argue waiver under 440.13, subsection 2F, because as the JCC asserted, there's nothing in the statute that allows for waiver.
I understand, but what I'm saying is you're saying they didn't let this document in, but it sort of seems like he said even if you let it in, it doesn't matter on this other issue down here. Am I wrong there?
I believe the JCC said even if he let it in,
yes,
he would have found that
it was ambiguous, and it didn't necessarily represent an election of a second physician under 440.13.2 in the managed care.
I believe the JCC said that the claimant could have been asking for a second opinion. And as we addressed in our brief, there was no petition asking for a second opinion. There were no letters asking for it. In the carrier's response, we identified it as a change of treating doctor, and the claimant's attorney didn't even argue at trial that this issue concerned a second opinion.
Well, didn't the JCC say that Dr. Brown was professionally affiliated with Dr. Maxsound, and therefore that the statute hadn't been complied with, and there was no first election, so there could be a second election as well?
In essence, that is the judge's conclusion, and it was stipulated that Dr. Maxsoud was affiliated with Dr. Brown. However, at the time that Dr. Maxsoud was authorized as the change in doctor, the claim was being governed by a managed care arrangement, and therefore the change in treating doctor would not have been under 440.13.2F. It would have been under 440, .134, subsection 10C, which authorizes a change of treating doctors to another doctor in the network. There is no requirement that the new physician be unaffiliated with the previous physician.
So the issue on that point, I guess, is whether the change in the statute is substantive or procedural, is it not?
Yes, Your Honor.
Okay.
And as we've asserted, the provisions regarding change of physicians are procedural in nature, and there are several decisions from this court that support that. There's Butler versus Bay Center, and also City of Bartow versus Brewer. And in both of those cases, dealing with 440.13 subsection 2F, this court considered that statute to be procedural in nature. We've further asserted that the judge of compensation claims erred in concluding that when the managed care arrangement ended in January 1 of 2006, that the judge was incorrect in asserting that the claimant essentially got a clean slate, that there was a new or separate bundle of rights that would authorize the claimant to get a second change of physician. And we've asserted that was an error, and that the managed care statute, 440.134, essentially provides a procedural mechanism for providing medical treatment, the same as the other procedural provisions of 440.13. So it's not a situation where there's a separate set of substantive rights where the claimant can get a second change of physicians if there's a change from managed care to just statutory benefits under 440.13. In support of that, I would call the court's attention to the statutory language under 440.134, subsection 2A, in which the statute talks about managed care being provided as a procedural mechanism for providing medically necessary remedial treatment, care, and attendance, which is the same language under 440.13 subsection 2A. So it's essentially two different statutes talking about procedural mechanisms for providing remedial care, treatment, and attendance. The court, or the JCC, also erred in concluding that the claimant did not waive their right to a change of doctors under 440.13.2F by previously selecting Dr. Maksud. Our brief sets forth 9 separate letters sent by the office of the carrier or their attorney to the claimant's attorney regarding the request for a change of doctors that was received in or around October of 2003. There were letters sent to clarify the request for a change and then to confirm that Dr. Maksud was being requested as a one-time change in treating doctors. And Exhibit 6 deals with a handwritten note that the carrier's attorney received from the claimant's attorney indicating that Dr. Maksud was being selected. And so it's our position that...
What exactly did the note say?
The exact language is, Maksud is alt ortho, thanks, and then a scribbled signature.
And I take it your position is, in light of the numerous letters that had preceded this response, it should have been clear to anybody what that meant.
Yes, Your Honor. There had been 2 letters sent, as well as 1 or more phone calls, as referenced in the letters, indicating that there was efforts to communicate with the claimant's attorney to clarify their request for an alternate doctor. The first letter is November 10th, and then there's a second letter, November 14th, which references some phone calls on November 10th or 12th. So there were efforts to communicate, and then our office received the fax with a handwritten note. And then there were 7 letters sent after that to, again, further clarify and confirm the selection of Dr. Maksud as an alternate orthopedic treating doctor.
And in fact, the claimant in this case began treating with Dr. Maksud.
That's correct.
Which would suggest that she understood what the arrangement was here.
Yes, Mrs. Galva treated with Dr. Maksud for 3 years or more.
Dr. Maxud also perform surgery on the claimant?
Yes, he did. I believe it was in the early part of 2004.
And I take it the signature on this handwritten note was indecipherable?
That's correct, Your Honor.
And opposing the claimant's lawyer didn't offer to acknowledge that this was signed either by him or somebody in his firm?
Well, at trial, there were two instances where the judge of compensation claims asked the claimant's attorney about that. Once during some questioning during the time when witnesses were being questioned, and then also at the closing arguments. And in both instances, the claimant's attorney at the trial, who was not Mr. Zaldivar, it was his associate, essentially claimed that he didn't know. And,
but it seems like to me that there's at a minimum a professionalism issue involved there, and perhaps an ethical issue as well, if in fact the lawyer did know and claimed he didn't.
We don't have any way of establishing what the associate knew or didn't know about whether Mr. Zaldivar had signed a note a couple of years earlier.
This is supposedly a self-executing system, and when one side goes to the effort that the employer and carrier went to in this case to get the other side to tell them exactly what it was they were doing, and we have these sorts of games going on, it becomes very disturbing.
Yes, Your Honor.
That's just an observation on my part. You don't get the same.
Well, at trial, we did strenuously argue to the court that we had made numerous efforts to clarify the request for a change in doctor and were not receiving responses. And
the JCC indicated something about that the claimant might have gone to see Dr. McStout about a second opinion. What's your comment on that? And I know that he treated the claimant for three or 4 years, but did the claimant go there initially for a second opinion? Is anything in the notes that indicate that?
I believe the JCC got that because Dr. Maxud's initial treatment report at the top says second opinion and treatment. And, you know, again, we can only speculate as to why Dr. Maxud wrote second opinion. I indicated in the brief it's perhaps because he is in the same office as Dr. Brown, who had been treating Mrs. Galva, so Dr. Maxud may have been aware of Dr. Brown's treatment.
Well, and in fact, she was looking for a second opinion and treatment, wasn't she?
She was only looking for a change in treating doctors.
But she wasn't happy with the one she had. That's why she was changing, isn't it?
Presumably, I don't believe they ever gave us a reason as to why they wanted a change from Dr. Brown, but from our standpoint, it didn't really matter. If she wanted a change, we were going to give it to her. But a second opinion is typically a one-time consultation.
It's not 3 years of treatment, including surgery.
Exactly. And the petition only asked for a change in treating doctors. There was no request anywhere for a second opinion. It's never referenced in any of the letters or pleadings, and it wasn't even argued at trial.
Mr. Crotty, you're into your rebuttal time.
Okay. Thank you, Your Honor.
Mr. Levy.
Good morning, Your Honor. May it please the Court. Jay Levy on behalf of the appellees. I want to correct something first. The issue as framed and the issue that was tried below was only whether or not this was an affiliated doctor. At page 399 of the record, the defense was they've had their one-time change of physician. The argument that the managed care system provides anybody in network was never raised below and is raised for the first time before this Court, and respectfully for the first time, I believe, in the reply brief. That was not the way this case was tried below, and therefore issues should not be raised before the appellate tribunal, as it is not the court of first resort, and we would ask that this court give that particular argument no moment whatsoever and address this case as it was tried.
All right, Mr. Levy, he's made 4 arguments to this court. How many of those do you maintain were not preserved, and which ones are they?
Well, in the brief, the only one that I have had issues with is the estoppel argument. I would point out to the court that estoppel is thrown around for about 5 lines on 1 page, but the specific argument was not raised below. And that would be the only one of the 4 that I contend. But this one that was raised this morning really is not even in a point. It comes up in part of the argument. That was not raised below. The note, Judge Webster, as you've noted, and I obviously did not try this case below, but the note was contested as being unauthentic. That's all I can tell you to answer your specific question, but your professionalism concerns obviously concern me too, but that was the way the case was presented, and I have to assume the counsel were acting honestly and fairly when it was made that representation.
Well, Mr. Levy, even if the note doesn't come in, there are zoodles of pieces of circumstantial evidence indicating that your client intended to exercise her one-time right to change physicians.
No, I disagree, Your Honor. There is gazillions of evidence that my client intended to change to a different doctor, but whether that was intended to be the one-time change of physician is not necessarily clear from this record.
But, Mr. Levy, isn't that the one-time change is the only sole right that the claimant has to make the change? So how can we say that that wasn't what he was doing there?
Except that this was a change that was clearly outside of the specific statutory language upon which this case was tried. This case was tried as to whether or not you could make a one-time change to an affiliated physician. The statute in question clearly says it must be an unaffiliated physician, and they stipulated that these two doctors were in the same practice and therefore were affiliated. So the issue is, does a change of doctors to an affiliated doctor constitute the one-time change? Respectfully, we suggest that there is no evidence to establish the intent that it be the one-time alternative change. Now, I wish to correct something in my brief. In my brief, I said that none of the prior correspondence uses the word one-time. There is a letter, one letter, I think, that talks about a one-time change.
November 26, 2003. Well, there is that one at least. There may be another one, too.
Well, that may be the one. There's also a letter that goes from the carrier thereafter on December 5th that says, please tell us if this is your intended physician change. We don't know. So there's correspondence, as I pointed out in my brief, before and after. There's indecision on the part of the carrier.
The reason there's indecision is because your client's lawyers were not responding as they had an ethical and professional duty to do to the numerous written requests made by the employer and carrier's lawyer.
The record does not show any response in terms of a written letter. I can't argue with you on that, Judge Webster. On the other hand, though, in the absence of a suitable response, there should have been no action on the part of the carrier.
And then they'd have been sued for that, wouldn't they?
And then we would be sitting around going, where's the response showing the change of physician? The point here is, is that there was no showing that it was intended by the claimant that this would be the one-time change of physician within the meaning of the statute.
Well, Mr. Levy, I have to tell you, I think that issue is a red herring. I think really what we need to focus on here is the statutory issue, because you really got 2 statutes here, don't you? And the question is, which one controls?
No, Judge, I don't think that that's the issue at all, respectfully, because the judge of compensation claims, that issue was not raised before the judge of compensation claims. This was tried. If you look at pages 397, 398, 399 of the record, the judge says, please tell me what the issue is. And the question is this our one-time change of a physician, within the meaning of that statute, and the carrier says at 399, that's the issue. They already got their one change. And that's the only issue that's tried in this case. It's not tried as a managed care case.
But don't you have to, of necessity, resolve the statutory issue to determine whether this is the one-time change?
The parties tried this case applying solely that one statute. That's the way the case was tried. It was not tried as a managed care case, and that this could be any doctor within the managed care network. This was tried, can they get this doctor, and does that waive their one-time, is that their one-time change position under the non-managed care statute, or does that constitute as the one-time change, and therefore the refusal to authorize another doctor after Dr. Maxud is not required, because they already had their one-time change. That's the way the case was tried. That was the issue that was tried. And to say that it's something else now is simply wrong, and it does no justice to the JCC who tried that specific issue, Your Honor. The memo that is the focus of this dispute is ambiguous, but even if it was not, we contend that there was no appropriate predicate laid there was no establishment of the authenticity of that letter. Now, I know that Your Honor has pointed out that it's one of a series of letters. My case would be substantially weakened if the shepherding witness had been somebody from the ID law firm, but the shepherding witness was someone who had no connection with that letter. It was the adjuster who was presently on the file and who had not been the adjuster at the time the letter was written.
Mr. Levy, what about the reply letter doctrine? I mean, wasn't this handwritten reply put on the letter that had been sent by the employer and carrier to the claimant's law firm?
Your Honor, there was a letter sent to the law firm. There was a letter that was, this letter was on a letter that was, yes, Your Honor. But the problem is, there was nobody to say that that was the way the letter was received. There was nobody to say that that was a true copy of the letter that was in the law firm's file. There was no one to say, for example, no one testified as to how the fax machine worked, as to when those markings on the fax machine would be made. There was no one who testified.
Mr. Levy, isn't it just almost absurd to be sitting here making this argument with these letters back and forth? I mean, in other words, to me, it's just as clear as it can possibly almost be made that this letter was properly authenticated by what happened afterwards. And, you know, to me, I think the issue here is for the claimant is whether or not, the statutory situation, because I just don't see how you can convince this panel that this letter was what the appellant says it was. And, to go out and play games at a hearing defeats the whole process, as Judge Webster said, of the workers' compensation structure.
I understand what Your Honor is saying to me. All I can tell you is that I do not believe, in principle, that the appropriate authentication was shown, because no witness was properly brought forth to say how the law firm received the letters, that this was the way the letter came in.
But
let me go to the second point.
Yeah, I'm trying to say, get on to another point that I found a little more embracing.
Counsel, isn't it undisputed that this handwritten fax note was sent after the 6-7 letters were sent from the employer carrier to claimant's counsel?
No, Your Honor. No, Your Honor. You said 6 or 7. That would not be correct. I believe at best there were 2 before and 6 after. And some of the 6 after were saying, are you taking the change? Do you want the change? What's your position on the change? I mean, you have to look at, for example, the December 5th letter. And respectfully, Your Honor, they're all in a row in Volume 2 of the Record on Appeal. It's about 12 pages in there. But, no, this was the second letter this was a response to the second letter that came in, I think the letter of November 10th or the letter of November 12th.
What I'd like for you to assume is that letter is in evidence.
Yes, sir.
It should have been in evidence. Now, does your client prevail in this appeal, even though it should have been admitted?
I would think so, because as this case was tried, it's still an affiliated physician. and it was still a physician that was within the meaning of the statute, did not constitute a change of physician. I would assume that the legislature had a reason to put that particular provision in the statute, and that would be to get a truly second, I would assume a truly second independent physician to conduct the treatment. And that's why the legislature wrote into the statute that it had to be an unaffiliated physician. In this particular case, it was an affiliated physician. So, yes.
You say it's fatal, that it was not an unaffiliated.
It is absolutely not.
How about their waiver argument? That
Well,
they waived it by going forward without insisting upon an unaffiliated physician rather than taking someone in the same office.
the waiver is the intentional relinquishment of a known right. Merely because we go to this doctor, I don't see how it constitutes the waiver in and of it. That act in and of itself would constitute the waiver.
How about because you go to that doctor after the employer and carrier's lawyer writes a letter to your client's lawyer saying that you want to confirm that the choice of Dr. Maksud is her, quote, one-time change in treating orthopedic physician, close quote.
Then I would turn to Your Honor, and I would say that at page 239 of the record, on December 5th, 2003, the letter is written to Mr. Zaldivar. Do you or do you not want to change a physician from Dr. Brown to Dr. Maksud? And the prior letter before that also does not necessarily address the issue of whether that is the one-time change. Now, those are the two most recent correspondence positions, before or after. I would say that the issue of waiver on these circumstances would be a question of fact. The judge ruled that there could be no waiver here, and that therefore there is some evidence to support what the judge did, and there would be.
I thought the judge more or less said you couldn't waive it as a matter of law, not
fact. The judge did say that, Your Honor, but my point.
How do we get to a question of fact rather than a de novo review of a question of law?
Well, then my answer would be to Your Honor that that matter would have to be sent back in all candor for a determination as to whether there was a waiver. But we think that, well, my position is self-evident. We believe that that letter was properly excluded, that there could be no waiver, that there was no evidence of waiver ever adduced to establish that there was a waiver of the unaffiliated rule contained in the statute.
What about the December 15th letter? December 15th, 2003 letter, I take it. It said, the EC has been advised that claimant wanted to change from Dr. Brown, and in fact she chose Dr. Maksud and went to see him last week. That acknowledges the requested change from Dr. Brown to Dr. Maksud, as I see it. If I am missing something here, please advise. Otherwise, the EC is of the understanding that the change of orthopedist has been accomplished, and Dr. Maksud, not Dr. Brown, is now the authorized treating hand specialist. Was there ever a response to that from the claimant's lawyer?
I don't see that there are any responses in this record to any of these letters.
Despite the, if I am missing something here, please advise.
No, there does not appear to be a response to that letter. But I would indicate that that letter, which appears in 240 of the record, nowhere indicates that this is intended to constitute a one-time transfer to an unaffiliated doctor.
And that argument might fly if we're looking at one letter, but we're not looking at one letter here. We're looking at a series of letters over several months. And when you read them all together, is there any other reasonable conclusion you can reach?
The reasonable conclusion that can be reached is that there was a change of physician that was requested. Whether it was to be the one-time change of physician in lieu of a change of physician to an unaffiliated physician as required by the statute cannot be concluded from these letters. Respectfully, we would urge this Court to affirm the order.
Thank you, Mr. Levy.
Thank you, Your Honor.
Mr. Carty, you have a minute and 57 seconds, I think.
May it please the Court? In rebuttal, there are a few points I wish to make. First, in respect to the argument that the issue was a request for a change to an unaffiliated doctor. I would point out that the petitions for benefits that were filed, I believe September 30, 2003, which was the first PFB in this case, and then the one from March of 2006, which the appellee asserts in her brief is the PFB that was the one that was at issue at trial. Both of those PFBs asked for alternate orthopedic doctor. And the appellee in this case now seems to be saying that the March 2006 petition, clearly was asking for a change in, or for an unaffiliated doctor. But at the same time, if that PFB has the same language as the first PFB, which the appellee asserts was asking for a change in affiliated doctors. So I think the appellee is trying to have it both ways here. Two PFBs, same language, asking for alternate orthopedist, but apparently the appellee asserts that those two PFBs mean two different things. Also, I would call the court's attention on the waiver issue. The November 14 letter, which is in the record at page 244, references, I believe, telephone communication between the law firms. Basically, the paralegal in our firm was contacting Mr. Zaldivar's firm, and the November 14th letter references the claimant's selection of Dr. Maxsood. So again, on the waiver issue, we wish to point out that not only did the claimant see Dr. Maxsood, but the claimant is the one who selected Dr. Maxsood. And then last of all, I point out the letter of November 10, 2003. It's the first letter we sent, and it referenced a new doctor being in the network as far as the managed care issue. And I see I'm over time.
Thank you, Mr. Crotty. Thank you both. We'll take a 15-minute recess now.